we go. Hi, everybody. Good evening. Welcome to our part 2 of the CEI Board Leadership Certificate course. Tonight, we're talking about association rules and conflict resolution. We have a great speaker tonight. We have Sarah Biltman from Gateway Law STL. Sarah is our current membership committee chair for CEI, and she's also a past CEI board president. So we're real excited to have her tonight. Sarah, I'm going to hand it over to you.
Okay, thanks, Kathy.
No problem.
Thank you, everyone, for joining us this evening for your CAI Board Leader Certificate course. This is Module 5, but we're taking this all a little bit out of order based on speaker availability. So no need to panic if you think you missed 1 through 4. So tonight we're going to talk about association rules and conflict resolution and some best practices for accomplishing both of those. Our learning objectives tonight are we're going to talk about 6 criteria to determine whether a rule is valid or not. We're also going to describe the procedure for developing association rules and describe the basic steps for enforcing association rules, the procedures and guidelines for conducting hearings, and lastly, some alternative methods for resolving conflict and avoiding court. So as we go through, this session is typically, it's pretty interactive. Unfortunately, given our circumstances, thanks to COVID, that's not going to be as interactive as it would otherwise be. I can't see any of your beautiful faces, unfortunately. I really enjoy presenting to CAVLs and sharing what I've learned through the course of my career and helping others, you know, get past some obstacles and learn some best practices. But our format is going to be a little less personal this evening, so please bear with us. And if you have questions, you can at any point in time type them into the chat on the bottom of your screen, on the bottom of your Zoom app. Those will be more than likely held to the end. If they pop up and I can see them, I will certainly address them if it's time appropriate, but otherwise we're just going to proceed and address questions at the end. Some of you have ordered the workbook, and you can go along with the presentation in the workbook. There's some additional discussion points and samples and worksheets throughout, and that's also a good place for you to take any notes that you might feel are relevant and worth taking notes on. So let's see, got some beautiful photos here. And what are some of the reasons that we all like to live in a community association? What are the reasons why you moved into a community association? Think about that for a moment. And some of those responses might be increased quality of life, increased amenities, property values, and a strong sense of community. Those are all typical popular responses for why an individual or a family decides to move into a community association. But as you know, along with all of those benefits come rules and regulations that every community association uses to govern the way that owners are permitted to conduct themselves and permitted to use the amenities and for maintenance of property. Critics of community associations oftentimes ignore all of those benefits and focus their attention on the occasional snag, rule-based disputes that owners might have with the board. And the fact that community associations are continuing to grow in number really shows that those benefits are ignored or misunderstood by the critics. So an independent national survey of community association residents was commissioned by the Foundation for Community Association Research in 2020. So maybe one of the few good things that came out of 2020 so far anyway. So what do you think? According to the survey, what percentage of residents believes that their association rules protect and enhance property values? I wish I could see hands and all that good stuff, but so take your best guess, and the answer is,
Sarah, we do have one person that replied 90%.
Oh, excellent. Well, that is a little bit higher than the actual, but I like that confidence in the community association model. But according to the survey, 70% of the residents, oh, so I'm starting to see hands now, maybe. Okay. So I think my panel comes up only if someone types something. Okay. Oh, and then someone else said only 20%. So according to the survey, the answer is 70% of residents agree that the association rules protect and enhance property values, with only 4% disagreeing. So I guess that remainder abstained or didn't have an opinion one way or another. But 90% believe that board members absolutely, or for the most part, serve the best interests of the community. And that says a lot about the trust that residents have in their board and their volunteer community association leaders, especially since they're all volunteers. No one gets paid for this, right? So the importance of rules. Sometimes my slides don't want to advance, so let's see, please move away from this window. Here we go. Okay, so what's important about rules is that they do provide a function. One is they provide certainty and order in the community. They protect the freedom and the safety of the residents. They clarify provisions found in the governing documents. And this is where I've had somewhat recent conversations with clients where I've recommended drafting some rules, particularly with collections. The board was like, well, we don't need that. The declaration says what we're authorized to do and don't do. But I find that when you put when you put the authority that's in your documents, you draft rules and procedures in layman's terms and expand upon what the authority is and how you're going to exercise it. And, you know, very specifically, this is how we're going to handle this type of situation. You still allow yourself flexibility, but it clarifies what those provisions in the governing documents actually mean and what they say. And lastly, rules help protect the commonly owned resources and the property values. For example, the pool. No glass at the pool, right? If the lifeguard's not on duty, no one can swim. Things like that. All right, so in lesson 1, as I mentioned before, lesson 1, we're gonna learn the 6 criteria for making association rules. And this module explores the guidelines for making reasonable rules, tips for enforcing rules sensibly, and methods for resolving conflict effectively. So in this first lesson, you'll learn to apply the 6 criteria and determine whether a rule is valid or not, and also describe the procedure for developing association rules. And again, if you have your workbook, you can follow along and take notes as you see fit. Okay, so here we've got some owners. They live in Happy Acres Community Association, and several owners have been in touch with the board. And let's listen to what they have to say to their board. Okay, so this is where I get to role play. All right, so this first character, Stephen Kim. This is Stephen Kim. He calls your office and oh, this, okay, so this, I don't know how to make that go away, Kathy. I don't.
No worries. It's okay. No worries. Keep going. It's all good.
Okay. All right. So the first character is Stephen Kim. My 7-year-old son has fallen in love with tennis and he wants to practice with me. But I've just been told that children are not allowed on the association courts. Is that true? So that's our first owner with a comment, question, complaint. The second, this is Mrs. Palloy, and she's calling about the plastic flamingos that are in various yards this month. I know that certain neighbors find them amusing and adorable, but I don't. I'm concerned about property values and I want the board to do something about this. And then we have, then I'll give these characters names. So my wife and I just moved into Happy Acres and we're puzzled by the pet rules. It says the only place dogs can walk is a small field of grass at the back of the community. Our question is, how are we supposed to get our dog from our unit to the grass at the back of the community without walking through the community? So no association sets out to make controversial or vague rules, but you can see by these 3 examples that sometimes it happens. And board members have a responsibility to listen to their owners when they bring these situations to their attention, and review and revise the rules periodically as appropriate. So if a rule is outdated, ambiguous, or invalid, the board should eliminate it or revise it. So how do you know if oh my gosh, advance. Here we go. How do you know if a rule is valid? So maybe this will take as long as it would if we were interacting.
You're all good, Sarah. We're learning new skills. I keep saying we're learning new skills. So thanks for your patience, everybody, while we're figuring it out.
It's just so odd how some of these presentations go just seamlessly, and others, they just don't.
Sarah, I believe you're on mute.
Okay, can you hear me now?
I can, yes. I don't know if you saw the question. There is a question if you want to address it now. I don't know if you saw it.
Why don't you read it to me?
Yeah. It is very difficult to just revise our indentures to change or add new rules. We have to have an attorney 2/3 vote to make any changes. Indentures are very old and outdated. What's next?
Okay, that's it. These are rules. These are not indentures. So your indentures or your declaration or your covenants and restrictions, that is the document that is recorded in the Recorder of Deeds office. And that is what requires 67%, 2/3, whatever your documents or the relevant statute would require to amend them. So the authority that document affords the board and the association, we use that authority to draft rules. So much like the collections example that I mentioned previously. So if your indentures authorize the board to impose interest for delinquent accounts, to pursue collection efforts, to record a lien, the documents will give you this authority. But so then with that authority, you draft rules or policies or procedure that clarify that authority. So if you look back a couple of slides, I'm not going to try and go back because I worked so hard to get to this slide. But so the importance of rules, they have the gavel in the center. So what rules do is, in this slide said, provide certainty and order, protect freedom and safety of residents. And then the third one was clarify provisions found in the governing documents. Okay, so these rules are not, they're not changing your recorded governing documents. They're drawing from the authority that is in your documents. And this next part will speak to that a little bit more. So, so hang in there. So how do you know if a rule is valid? Okay, that's step one is it legal? And in order for it to be legal, that's one of those elements is, do you have the authority in your recorded governing documents? So,
Sarah, you're muted again. Sarah, did you hear me?
yes.
Sarah, there you are. Okay, good. We can hear you again.
It's really fun when it does this, when I'm in Zoom court, when it just mutes me. It's awesome. So how do you know if a rule is valid? So there's 6 criteria, and there's these little tags on the slide here.
Sarah, you're muted again. Oh, there you go.
Okay.
We can hear you
A
again.
rule is legal when it does not unreasonably restrict a constitutional right. And I wish that would remove itself from the center of the screen also. And it has to be consistent with federal law, state law, local statutes, and the governing documents. And that's what I was referring to before. So in order to create a rule or revise a rule, it doesn't necessarily require any revision of your governing documents. If the authority is already in your documents, it won't require that. So, and that again, if it does not exceed the scope of the rulemaking authority, and that comes back to your documents as well. So the next is a rule must have a legitimate purpose. So a rule has a legitimate purpose when it relates to the operation and the mission of the association. For example, a rule banning residents from owning jet skis would not have a legitimate purpose if it's a lakefront community that advertises for residents to enjoy the aquatic environment and related water activities. They're counterintuitive. So if you have a lakefront community advertising, you know, live on the water, have fun in the water, and you don't let anyone have jet skis, that is not a legitimate purpose for that rule. So you also want your rule to be reasonable, and it's reasonable when it's just and sensible and is not excessive or petty. So another example, a rule requiring a resident to obtain a parking pass, a guest pass to park, requiring them to have a 30 days advance notice on a request for a guest parking pass that's not reasonable. I mean, does anyone's mother-in-law give them 30 days advance notice, or their kids for that matter? No, 24 hours would be a more reasonable time frame to request a guest pass. So next, we want the rule to be fair. So a rule is fair when it does not single out or discriminate against a separate class or group of people to be treated differently without reason. So a rule stating that tenants who lease their unit from the owner, if the rule said that tenants may not enjoy the common areas or the amenities, that would be an example of an unfair rule. And you want to make sure that your rule is enforceable. Can it be applied uniformly rather than selectively or arbitrarily? So here's an example. If your rule states that no unattractive yard art may be placed in the front yards, that would not be enforceable because the description unattractive is subjective rather than objective. And who's to say what constitutes unattractive? And so lastly, we want our rule to be clear and not confusing. So it must be stated in a way that eliminates ambiguity and confusion and compliance and enforcement. So another example, door decorations. So if you're trying to limit door decorations and say, and the rule says that only tasteful decorations are allowed. Okay, again, that's subjective, not objective. So how is that clear to anyone to understand what the rule means, much less abide by the rule if it's not clear what the rule means? So the best practice is to consult your attorney, your association attorney, on the validity of the rules. And some associations contract with an attorney to do an annual review of what they're doing, and is it still working? Is it legal? Should we change? Because remember the legal slide, there may have been statutes, federal statutes, state statutes, local statutes, or case law that have been imposed that now the rule that you used to have in place may no longer be legal. So that's where consulting with an attorney on a somewhat routine basis helps you to make sure you're still in that legal category. Okay. So now we're going to talk about the procedure. So invalid rules can be traced back to the absence of a formal rulemaking procedure or failure to follow an existing procedure. So being familiar with these 8 basic steps help keep you on the right track when you're drafting your rules. So the first step is to identify or confirm the association's authority to make a rule on the matter. And so again, this goes back to your authority will be found in your governing documents that are recorded and are very difficult to amend, as we discussed, and also to your local, federal, and state statutes. So again, we recommend that you enlist the help of your attorney to make sure that you're compliant in those areas. So in the case of Happy Acres, the tennis court issue in our opening scenario, the association's attorney agreed with Mr. Kim that the rules should be revised. The board did not have authority to prohibit children from using the association's tennis courts. So step 2 is to ask yourself, why is this important? Why is this rule important? Why are we even imposing this rule? So to avoid knee-jerk reactions and thinking the solution to any given problem is simply imposing a new rule, for example, creating a ban on pink plastic flamingos in response to Mrs. Palloy's one-time complaint. That might have been an overreaction if the board imposed such a rule. But when there is a real need for a rule, check to be sure the rule does not already exist in your governing documents. So maybe there is already a restriction in your recorded documents prohibiting yard art of any kind with no subjective context. Sometimes it's just unclear, or it just hasn't been enforced for so long that people don't realize that it's there. So the third step is considering the immediate impact as well as the long-term implications of the rule that you are trying to impose. How will the rule be received? Will there be resistance? Will a solution to a current problem create future problems for the community? And also consider, how will the rule be enforced? So if you impose a rule that has to be enforced, how are you going to do that? Are you going to impose fines? Are you going to, and if that's your plan, do you have authority to impose fines? Do your documents limit your enforcement to filing a lawsuit? So you want to consider, how will this rule be enforced? And then the fourth step is defining the scope and writing a draft of the rule that you have in mind. The what of a rule includes the required steps, procedures, acts, or prohibitions a person is expected to follow. The enforcement procedures, the penalties for violations, and your due process procedures. So this is the rule. This is what's required. This is how we're going to enforce it. This is what will happen if you do not comply. So it's important to state the rule in simple, positive terms, not so militantly in a negative or complicated. Owners tend to ignore those. Keep the rules flexible as well. So sometimes owners may need options, and inflexible restrictions promote resistance. For example, instead of banning tool sheds or outbuildings altogether, allow sheds in the backyard so long as they are not visible from the street. So the difference in wording might be tool sheds are prohibited. Or you could phrase it, tool sheds are permitted provided that they are in the backyard and not visible from the street. It invites compliance. So if the language you're using itemizes what is or what is not allowed, remember, this is important. This is this is a general rule of law. When something is omitted from the list, it's omitted intentionally. So if you are listing off things that are prohibited, if you don't include something, the reader assumes that the drafter omitted that item purposefully. So if you're listing off things that, if you're trying to make a comprehensive statement of possibilities, for example, pets, no dogs, cats, birds, lizards, no pets allowed, including but not limited to dogs, cats, lizards, birds, etc. So you include that language, including but not limited to, and that opens you up for even a ferret. So who would necessarily think to include every exotic animal in their documents, potbelly pigs, and who knows what the next exotic pet is going to be, peacocks. So including but not limited to. So step 5, this is when you want to contact your attorney. You've already established that you've got a problem to address. This is what we want the rule to say. This is how we're going to enforce it. And now you call the attorney and you want to make sure that the rule is enforceable. So your attorney will be able to verify that it's legal, it's related to your community's purpose, it's reasonable, it's fair, enforceable, and clearly stated. Step 6 is to give notice. So you want to give notice of the proposed rule to the owners and the residents and solicit their comments and opinions. You can propose the rule via newsletter or write an open letter to the association. You can bring it up as a discussion topic at a annual meeting or special meeting and invite the owners to ask questions, voice opinions, and even just submit those in writing. If it's a major matter, something like a town hall is probably a good idea. But you don't want to surprise the owners with a brand new rule that all of a sudden is imposed. Some of your documents allow you to do that. This is a best practice. This is not necessarily a requirement in the state of Missouri. However, some of your documents may require a notice and comment. Some actually may even require a vote of the owners at a meeting. So you definitely want to make sure that if you have any strict procedures that they're complied with. And your attorney on the previous step, step 5, will help guide you through that. So step 7 is voting on the rule. And oftentimes the only vote required is for the board to vote on the rule. They typically have the authority to promulgate and adopt rules without a vote of the owners. But like I just said, some of your documents may require a vote of the owners. it's not usually a vote that's as burdensome as amending your documents, but they're all written a little bit differently, especially with HOAs instead of condominiums. So you just want to make sure that you're following the correct legal process in adopting your rule. So at the meeting, the board would have the option to either approve the rule as it's written, to approve the rule in some amended form, or to reject it. And then whatever the board votes would be recorded in the minutes of the meeting, including the text of the rule. So step 8 is, after the rule is adopted, sending final notice to the owners so that they know that the rule was in fact adopted and when it goes into effect. You'll send notice to each owner at their last known address in the community's records. And if there is an occupant that's a renter, you would send it to that renter as well, because as we all know, renters are expected to comply with the rules of the community as well. And you can publish in the newsletter, and if you have a common area, you can post a notice of that new rule in the common area as well. And if you have a rules and regulations booklet, pamphlet, whatever, you'll want to be sure to revise and update that publication and include the date. So a lot of communities have a booklet that they provide to owners when they move in, but it doesn't say the last time that was revised. So, or they don't know which one is the most updated. So that is, if you're doing something like that, be sure you're dating those materials so that you know which is the current and effective rules and regulations for the community. So the benefits to following this formal procedure in drafting rules, first of all, it discourages reactive rulemaking and promotes a deliberate approach to making rules. It clarifies the scope of the board's authority, because you're drawing that authority directly from the governing documents. And it eliminates the possibility of creating invalid rules. It mitigates it, nothing else. But by consulting your attorney, it should virtually eliminate the possibility of creating invalid rules. And it provides a formal record of all of the rules that are made, because when the board votes and adopts them, you're including them in the minutes for the board meetings. And it protects owners from arbitrary board action. And I think these are all pretty beneficial to community living. And it's beneficial when you have formal rules in place. Whoever is on the board today, well, they might not be on the board next year or the next year, and they might not have been on the board last year. So when you have rules in place, it it helps do a couple of things. It helps tailor your own specific community. Every community is not different, or it's not the same. Every community is different. And rules that might be necessary or work very well in one community, it might not be necessary or work well in another community. So especially if you're a new community, as the developers stepping aside and the owners are taking over operation of the association, these rules can be drafted to really tailor to how your community interacts with one another, how the owners act and behave and treat each other, and they can be very personalized in that sense. But it also helps to create consistency from one board to the next board to the next board. It sets, not in stone, but it sets the stage for managing expectations of owners, for one, but also provides a guideline for new board members. This is how we deal with this type of situation. So that provides consistency. And that's what this last bullet point, protecting owners from arbitrary board action, that's very important. Okay, we're going to do a knowledge check now. So the Board of Island Marina Townhomes observed the community had no rules about boats. So it asked the manager to put together a set of restrictions. The board approved the rules and they were mailed out. In the 2 years since, the residents have generally ignored the rules, and the board wonders why. So this reminds me of the jet ski example. So which steps did the board fail to follow in this example? So did the board evaluate the need for the new rules based on our facts? Doesn't say that they needed any rule about boats. They just noticed that they didn't have any rules about boats. So let's get some rules about boats. So I would say they didn't follow that step. Did they verify that the proposed rules are valid and enforceable? Again, we do not have any facts to support that they did that. Did they give notice and allow owners an opportunity to comment? No. So they bombed. They bombed on this one. So as a result, the owners are ignoring the rules because there's no valid purpose for the rule, and so no one's following the rules. So next example, Majestic Mountain Community Association is adjacent to a state park. While walking in the park, Miss Cratchit, an owner, was accidentally bumped by a neighbor who was jogging. Miss Cratchit now wants a rule that all residents must refrain from running on the park's mountain trails. The board decided that this rule would not be valid. So why would a rule like this not be valid? Is there a legitimate purpose related to the association? Not apparently. Does this rule exceed the board's authority? More than likely, because it's on the state park, and therefore it's likely unenforceable and discriminates against owners. So we're going to give this one 4 reasons why we cannot pass that rule for Miss Cratchit. Sorry. All right, so here's some examples of some rules. And we'll go over why each one is not a good rule. So rule number 1, a first floor owner may be assigned 2 parking spaces, but second floor owners are limited to 1 parking space. Well, that's just unfair. And rule number 2, no business of any kind can be conducted from a member's unit. Well, good luck enforcing that. Rule 3, dogs are restricted to poodles, schnauzers, dachshunds, Pekingese, chihuahuas, and toy terriers. Well, that's just unreasonable. Rule 4, owners shall have their pets on a leash while on the common areas and while on any city property adjacent to the common area. Well, this says there's no legitimate purpose, but I believe there is a legitimate purpose for pets to be on a leash, but I think that this rule number 4 is also unenforceable, because if it's on city property, the association wouldn't have any grounds for enforcing such a rule anyway. And rule 5, paint colors should be muted earth tones except for pastels. Well, what does that even mean? That's very unclear. And rule 6, residents are prohibited from flying flags or decorative banners of any kind. Of any kind. And that's illegal. So, those are some examples of unenforceable rules. Okay. So which of these rules is stated in a way that encourages rule compliance? That no trash may ever be placed on the street before 8 p.m. on the evening before the day of collection. It is strictly forbidden to extend fencing beyond the rear foundation line of the unit. Recreational vehicle parking is permitted in designated spaces only. So you can see how this option C is worded in a more positive. This is what you can do, as opposed to A and B are written in a very, you may not do this, that, or the other. This is forbidden. So when you are able to phrase your rules in a more positive way It's like an invitation for owners to do things properly, or in an acceptable fashion. So like, for example, no trash may ever be placed on the street before 8, blah, blah, blah. Okay, well, I leave for work at 6 o'clock and I work overnight, so I'm bringing my trash out when I can. Instead of, this could be worded in a way that tells the owners how they can and should put their trash out on the street. So rules stated in positive terms that invites and encourages compliance. So on to lesson 2, enforcing rules. And rule violations do occur. So this will help us to learn how to enforce the rules. So the basic steps for enforcing rules. All right. So Mrs. Sanchez saw her neighbor let his German Shepherd run without a leash in the common area. It wasn't the first time. She called you to express her concern that the large, unleashed dog might intimidate others, especially children. You thanked her for the information and assured her the board would follow up appropriately. So what does that mean, to follow up appropriately when an alleged violation occurs? This lesson will help clarify your responsibilities in following up on an alleged rule violation appropriately. So having rules on paper is not enough. The intended benefits of association rules cannot be fully realized unless they're enforced consistently and fairly. So enforcement means having a due process procedure in place to handle any infractions, as well as a way to handle appeals and exceptions. Due process is a legal term, and it is the official or formal way of doing things in accordance with established rules. It guarantees the principle of fairness will be applied in all matters. It helps prevent arbitrary or unreasonable treatment. So due process guarantees the principle of fairness will be applied in all legal matters, and it is derived from the 5th Amendment to the United States Constitution, which states that no person shall be deprived of life, liberty, or property without due process of law. The basic steps in due process consist of a cease and desist letter, a hearing notice, a hearing, the decision at that hearing, and an appeal. And before initiating the formal process, many boards prefer to attempt to resolve a situation informally prior to plowing through with the cease and desist and a hearing. So this is usually done by making a phone call or sending a letter or an email to the alleged violator. And ideally that results in an open conversation or discussion about the matter. And if that informal process is ineffective, then we start with a cease and desist letter. Now, cease and desist letter is an official notice of the violation. It should include the action required to end the violation, a specific time frame in which the violation must be corrected, and the penalty or sanction that may be imposed if the violation is not corrected. If the violator does not correct the violation within the time frame specified in the cease and desist letter, the next step is a notice of hearing. The hearing notice is a written notification that a hearing will be held to consider the violation. Now, when I write my letters to owners, I write mine notifying them of their right to be heard, their opportunity and right to be heard, and place that burden on the owner to reach out to acknowledge the receipt of the notice and schedule the hearing. So this lesson basically says, this is when your hearing is, Tuesday at 3 o'clock. Okay, well, I'm at work on Tuesdays at 3 o'clock. So I have a doctor's appointment every Tuesday at 3 o'clock. So if you phrase that, you can phrase your hearing notice in a little bit different way to accommodate people's schedules a little bit better. Okay, so the hearing is then.
Sarah, you're muted again.
Can you hear me now? Can you hear me again?
Yeah, I can hear you. Yeah, you're good.
Okay. I think it's when I go up there and I check on the chat. That's when it happens. Okay, so the hearing is the fact-finding inquiry and investigation of the allegation. And it is not a time to engage in additional conflict, but to hear the points of view of the people involved. And if the violator does not appear, then they are in default. So the hearing panel, they judge on whether a rule has been violated and whether a penalty will be imposed, what type of penalty, terms, and enforcement date. So some associations, your hearing panel is simply going to be your board of directors. Some communities, depending on the level of involvement, the size of the community, what the documents say, some communities might have a hearing board or hearing panel that would hear the pleadings, so to speak. And whether a penalty will be imposed, that depends on your authority. Do you have authority to fine? Is the fine or penalty that you're trying to impose consistent with your fining schedule? Is it consistent with the violation that has occurred? So your panel or your board will make a decision based on all that. And so your owner, this appeal is not, it's a best practice, but it's not required in the state of Missouri unless your documents say that they have a right to appeal. So this this will depend on what your documents say. But typically, if an owner doesn't like the decision, I mean, they can ask for an appeal, but otherwise you are then in a position where you have to enforce whatever your decision was. So that appeal might effectively, and from a practical standpoint, be the court when you try to sue to enforce it. So yeah, so you would want to consult your attorney if going through those steps. So the benefits of using due process is, again, that these rule violations are handled in the same manner. And some state statutes require a due process. In Missouri, the Uniform Condominium Act, which governs all condominiums, that is going to apply to condominiums. When you're dealing with an HOA or PUD, you know, townhomes, single family homes, something that is not a condominium, then those communities are very document driven, and it's going to depend on what your documents say. So the courts recognize due process as an indication of a legally valid rule enforcement. So if you go through the hearing process and you're applying, your rule was passed properly, it was violated, it was brought to the person's attention, they were given an opportunity to cure, they didn't, you offered them a hearing, they had a hearing, and the ultimate determination was, no, this is a violation and the penalty imposed is appropriate given the circumstances. The court will recognize all of those steps that you've taken. So that will go a far way if that ends up in front of a judge. So the majority of rule violations can be resolved with this hearing procedure. And it often results in voluntary compliance because it gives an opportunity for the person to be heard. So let's do another check. So Sarah is the head of the compliance committee at Bayview Townhomes, a small self-managed community association. One of the owners, Mr. Matthews, he still has holiday decorations on his front porch more than 15 days after the deadline to take them down, which is a violation of the rules. What should Sarah do? Well, let's see our options here. She could make a friendly call or send a courtesy letter. She could issue a cease and desist letter, schedule a hearing, or turn the matter over to the association's attorney. So each of these are individual steps in the enforcement process. However, our step one would be to attempt to informally resolve the situation. And a cease and desist letter at this beginning stage might seem a little unnecessary, and it's too soon to schedule a hearing because you haven't given any notice yet. So we would start with a friendly call or a courtesy letter. So her letter asked that the decorations be removed within 1 week. And at the end of the week, the decorations were still there. What should she do now? She could send another courtesy letter. She could issue a cease and desist letter, schedule a hearing, levy a fine. So sending another courtesy letter, especially in this situation where you just told him he has a week. And so if he doesn't do it in a week, do you send him another one that says you have a week? No, that would not be the appropriate step, because that sends a message that we don't enforce the rules. So the next step in the process is issuing a cease and desist letter, because we don't want the owner to think that there are no real consequences for noncompliance. So the details of the cease and desist letter, be sure to include the nature of the violation, the legal authority for the rule, the required action to comply, the compliance time frame or deadline, the penalty for failure to comply, and the contact information of the letter writer in case the resident has any questions. So it's important that the cease and desist letter has a neutral tone, encourages compliance, and avoids offending the recipient as much as possible. You want to send your letter by certified mail as well as by regular mail. And some governing documents require that you send a copy to the person who complained, but that would depend on your documents. Okay, so he still hasn't removed these Christmas decorations. What is she gonna do now? She could resend the cease and desist letter in case he didn't receive it. Well, we already talked about that. She's going to issue a hearing notice because that's the next step. I like that number D though, but that's not, if that's not what the letter said, then that's, so this escalating the problem to the board is not necessary, although depending on how your community is set up, scheduling a hearing might actually be the same thing as putting the issue in front of the board. So I don't want you to be confused by that. So the details of the hearing notice describes the violation, the action requested, the time and place of the hearing, an invitation for them to bring witnesses and legal counsel to attend, and the consequences for failure to appear. And so this is what I was mentioning earlier, that my notice of hearing tells them to contact the manager to schedule a hearing. So the purpose of the hearing is to allow all parties a chance to have their voice heard. And it should be an opportunity for the panel to gather information to make a decision regarding the violation and the penalty if appropriate. And without a set of procedures in place, the hearing can quickly get out of hand. So let's take a look at this hearing.
This meeting is called to order. Give me your attention. Let's get this thing taken care of. Joan, you have 4 dogs. They are a problem. And that's why we're here to decide what we're going to do about it.
If you could just meet my dogs, I know you'd see they're wonderful pets. I brought them with me. If I could just bring them in, I'd like you to meet Barky, Yippy, Yappy, and Snappy. They're such wonderful pets. I brought them, but they wouldn't let me in.
Now, we just really can't
I pet them. In fact, I know them really well. I hear them barking every time I'm at home.
You don't like pets. And there's nothing I can do about that, but that doesn't change the fact that they are wonderful dogs. Well, I got Barky when he was just a year old and he was a tiny puppy.
Well, I've been trying to sell my unit for over a year now, and every time the real estate agent brings a prospective buyer by, those dogs start barking, yipping, yapping, snapping, and I'm afraid I'll never get to sell it.
That isn't true. Please just let me bring them in. I know you would understand what wonderful pets they are.
You just don't understand. We just can't have dogs.
I am fed up with all the barking.
You don't have a pet, do you?
No.
I thought so. He doesn't like dogs. I can't help that. Yippy was abandoned when we adopted her. We've had her 15 years now, and she's grown to be such a sweet, sweet dog.
That's ridiculous, and it's not even the point. I can't sleep, I can't eat in peace, I can't watch TV in peace. I can't do anything without hearing that barking. I'm fed up, and it's up to the association to do something now.
And I am never going to get to sell my place with all this yipping, yapping, and barking going on.
Yippy is such a smart dog. We've had her for 4 years now, and she has always been well behaved. And Snappy is so cute. She has the perfect little markings on her face. If you just let me bring them in, I can show you how well behaved they are.
Okay. Kathy, can you still hear me?
Yes,
Okay.
you're all good.
Okay. So that was a hearing full of a number of problems. So right off the bat, there was no clear agenda. No one was keeping any order whatsoever. No one was in control of that meeting. Everyone was interrupting each other and they're insulting each other. So nothing got accomplished there. I think we can all agree. So now we have a quick example of procedures and guidelines for hearings. So this is how a hearing should go. A standard set of procedures and guidelines allows a hearing to proceed smoothly, and you want to have a chair if possible, and that can be the board president, that can be the manager, that can be the association's attorney, depending on the circumstances. Depending on the circumstances. So we start off, the chair opens the hearing and makes introductions and explains the purpose and the procedures, manages everyone's expectations. This is how this is gonna go. These are the rules. All remarks must be addressed to the chair. No cross communication between the complaining owner and the violating owner. After that, the chair invites the complaining owner to speak and ensures that the complainant can do so without interruption. Then the panel, whether that is a specific panel or committee that the association has, or if the board is serving the role of the hearing panel, and the panel asks questions of the complaining owner. And then the chair gives the violating owner an opportunity to speak and without allowing any interruptions. He or she is allowed to have legal representation present, as well as any witnesses and or evidence. And after that, the panel asks the violating owner questions. And then the chair invites the others to speak. And then the chair adjourns the meeting. So with those procedures in mind, let's take a look at same
All right,
violation.
let's call this meeting to order. I see that everyone has a copy of the complaint with them. For the record, my name is Andrew Edwards, and I'll be presiding over this hearing today. We're here today to discuss the alleged rule violation that was filed against Ms. Joan Shepard in Unit 203, specifically a complaint that was filed by Mr. Bob Thompson, alleging that Ms. Shepard's 4 dogs are creating a noise nuisance in violation of Section 3, Paragraph 5 of the association's bylaws. Before we go on, I'd like to explain how today's proceedings will go on. First of all, each party is going to have an opportunity to speak, and you'll have an opportunity to present any evidence or any witnesses that you have with you today. And when you're finished speaking, the panel will then have an opportunity to ask you questions. And then we'll hear from Mr. Thompson first, then we'll hear from Ms. Shepard. And I'd like to add a couple additional ground rules. First of all, no one will speak unless the chair recognizes him or her. And secondly, all remarks should be addressed to the chair, and that's me. All right, Bob, we'll start with you, and let the record show that we'll be hearing from Mr. Bob Thompson in Unit 204. Bob, what would you like to share with us about why you filed this complaint?
Thank you, Andrew. The reason why I filed the complaint is because I am sick and tired of hearing her dogs bark all day. I can't eat, I can't watch TV in peace, I can't sleep in peace.
But if you could just meet my dogs, I know you'd think they're wonderful.
Joan, you're going to have to wait your turn to speak. Bob has the floor right now, and when Bob is finished, it'll be your turn to speak. So, Bob, you can continue.
Yes, thank you. As I was saying, she leaves those dogs alone in the apartment all day long. This is while she's at work, and all I hear is just barking all day. I brought Jim in with me today, and he could tell you a little bit about it too.
Well, Jim, what would you like to tell the panel about this situation?
Thank you, Andrew. Thank you, Bob. I've been trying to sell my place for a little bit over a year now. And every time the real estate agent brings a prospective buyer, those dogs start barking and yipping and yapping, and the buyer runs away. I'm afraid that if we don't get this resolved, I'm never going to sell my place.
Well, does the panel have any questions for this gentleman?
I do. Bob, is the barking constant 24 hours a day, or is there a time where it's more constant than others? Or?
It seems pretty constant. Well, now that I think about it, it actually is much worse during the day. You see, sometimes I work at night, so I'm trying to sleep during the day.
Well, are there any other questions from the panel? No, if not, then Ms. Shepard, it's your turn to speak about this issue.
My dogs are such wonderful dogs, and I know you'd like them as much as I do. I just don't think Mr. Thompson likes pets. Look, they don't really bark that much. And when they do, I give them a treat and they quiet right down. I don't know what else I can do.
Well, Joan, what do you do with your dogs in the daytime while you're at work?
I feed and walk them before I leave for work. I leave them toys during the day, and I even leave the television on when I'm not home so they have company.
So So how do you know they're not barking all day if you're not there?
Well, I just can't believe my little darlings would misbehave like that. They're just so sweet when I'm there.
You know, Joan, I'm sure you have very wonderful dogs. We do, however, have 2 people who are testifying that they do bark all day. So perhaps we can discuss this and come up with solutions on how we might address the problem. I mean, have you ever considered hiring a dog sitter or having somebody come check in on them in the middle of the day?
No, I've never thought of that.
What a difference with a organized, controlled meeting. Everyone's expectations are managed, conflict to a minimum, and there was actually an opportunity for dialogue, an opportunity for respect, and an opportunity for brainstorming some type of creative resolution. Those are the specific improvements that I observed. And it's amazing what can be worked out in a civil manner, and how much further that can take you. So after the hearing, there is, of course, then the decision. So let's go back to Mr. Matthews. And at his hearing, he explained that he has been working overtime since Christmas, and then he was called out of town to help his sick mother. And while the committee was sympathetic, they ruled that the decorations need to be removed by the following Monday, or Mr. Matthews will be subject to a $5 per day fine until they were removed. Keep in mind, he's already been 15 days of 3. He's already, it's already well into January. January is almost over. So, so typically speaking, decisions are not given during the hearing, unless it is something that is worked out between the parties, if the complaining owner and the violating owner, through a civil discussion. Oftentimes that can happen, but generally they are not given during the hearing because it may give the impression that the hearing panel was predisposed and already had their mind made up prior to the hearing. Whatever that decision is, it should be written and documented and communicated to the violating owner within the mandated time frame. Is there a time frame in your governing documents? Is there a time frame in your policies and procedures for notice and opportunity to be heard? So that would depend on that. Penalties must be reasonable and consistent with what they have authority to penalize. It could be fines, it could be suspension of an owner's right to vote or use amenities. Not all communities have the right to fine. Not all communities have the right to suspend use of the amenities or the right to vote. So you want to make sure that whatever your penalty is, that it is in fact that the board has the authority to impose that. And any request for an appeal would require an action to be put on hold until the final verdict is reached. And again, appeals, that depends on your own documents. So, be sure to consult your attorney on how this should work for your own specific community. So due process, which statement is true? Due process protects the rights of the parties involved. It always leads to a satisfactory outcome for all parties involved. It typically leads to a court appearance, or it limits the exploration of resolutions. Well, I'm gonna start at the bottom here. I think that we saw in that second video that the due process hearing, when conducted properly, it actually encouraged the exploration of various resolutions. And then going up one, it was, well, we didn't get an end result to see if the dog sitter worked, but it did not result in a court appearance. Was it satisfactory for all parties involved? It's usually not, but what it does do is it protects the rights of all of the parties involved. Each party had an opportunity to speak and uninterrupted. The meeting maintained a level of respect for everyone involved. So that's important, very important when you are trying to resolve a conflict between owners and encourage compliance. So here we're gonna learn we're going to describe procedures and guidelines for conducting hearings and alternative methods for resolving conflict without going to court. So here are some examples. Homeowner paints her mailbox pink to support breast cancer awareness. Parents construct a playhouse in their backyard to help their disabled child. An environmentally and cost-conscious owner installs solar panels on her roof. And lastly, I don't even see this on here, but a renter nails a small religious object on the front door frame of her condo. So in each of these situations, these are real life examples where the condo association or homeowner association actually sued the owners who were in violation. And is that drastic measure necessary, or can we come to resolutions in a less adversarial, less time consuming, less expensive method? And that would be ideal, right? So when you sue the owners, everyone pays a high price. The board pays a high price. All of the owners pay a high price because the attorney's fees are paid by way of the assessments, which are paid by all of the owners. The violating owner is paying their own attorney. Expenses are high and emotions are high. And they can drag on for years and drain the finances. The damage can really outweigh the benefits. So why is it that some associations choose to sue? And I'm not saying you should never sue. I'm just saying sometimes it's drastic given the circumstances. So Allowing variances, is this wise or unwise? Well, according to attorneys who specialize in community association law, a primary reason board members decide to sue is based on a misconception that allowing a variance is unwise because it's setting a precedent that would they would be unable to disallow any variances in the future, but that's not actually the case. And while state statutes and governing documents must be reviewed first, the board should make effort to approve a variance or request if it is reasonable. And when you go through the process of obtaining a variance, any future owner would have to do the same thing. So let's take a look at some examples. What should the board do if an owner continues to be I don't have a slide for, we're still back here. Okay, example 1, Community ABC has a rule against running a business from an owner or resident's home. If the business cannot be detected, as in the case of a computer programmer, should a variance be granted? Yes, of course. It makes no sense to attempt to enforce this rule. How would you enforce it anyway? If the owner's business is recycling paper products and his driveway and yard have used newspapers stacked high with trucks coming and going at all hours, should a variance be granted? No, that would be ridiculous. That has a negative impact on the value and purpose of the community. Example 2, Community ABC has a rule prohibiting commercial vehicles from parking in the community. If an owner who always parks her commercial vehicle in the garage, concealed from public view, requests a variance, should the board members approve it? Well, based on the condition that the vehicle always remains out of sight, that would be a very reasonable variance to issue. Example 3, Community ABC has a rule prohibiting sheds. An owner reports that he saw a truck deliver a shed to his neighbor. He cannot see the shed, but he did see that it was delivered. During your next visit, you look at the home in question. You can't see the shed until you peer over the fence and the perimeter landscaping. If the shed owner requests a variance, should the board approve it? Well, so long as the shed cannot be seen, and you can revoke the variance for any reason if the shed becomes visible, that would also be a reasonable variance. But it seems like oftentimes what agitates the boards and managers more so than not is he put his shed up before he asked for a variance, right? That's what gets under our skin, isn't it? He could have asked first and maybe we would have said yes, but he didn't ask. So now we're mad. And that's how the emotions stay in the situation. And it becomes difficult to discuss the matter in a productive way. So what if the Or what should the board do if an owner continues to be non-compliant, or if the terms of the variance are blatantly ignored? So depending on the severity of the dispute, the best step may be to involve, get your legal counsel involved for particularly sticky situations. In a less severe case, however, turning the matter over to an attorney prematurely may trigger animosity prior to an opportunity to resolve the matter diplomatically between the board and the violating owner. So, okay, so we're gonna have 4 types of handling disputes. Alternative 1, the association has been trying to settle a dispute with an owner via email or letter. Try a different tactic. Pick up the phone. Real people talking with real people can accomplish miracles. At least reduce frustration and misunderstandings. And be sure to apply active listening skills, as previously discussed, and as previously discussed. Remain calm and collected and don't get defensive. I have a lot of owners who, when I send a demand letter, cease and desist, any type of letter like that, so for collections, for example, we all know that the management company sends out like how many notices before that account is ever turned over to my office for collections, right? And then I send a letter and they're so offended. They're so offended. No one called me. No one sent me a letter telling me that I was delinquent. It's like, well, I'm pretty sure that you've probably gotten at least 4 notices that you're delinquent. And why should we have to call you and beg you to pay your assessments like everyone else? So yes, people can oftentimes resolve a situation with a phone call. At least open the lines of discussion and demonstrate a level of respect to the other side. So, alternative 2, extend an offer from the board to meet with the owner at his or her home or another neutral venue to discuss the issue in person. Again, you're making an open effort to remain friendly and open. And alternative 3, sometimes discussing the matter with someone else, like an expert. So for example, a board involved with an owner over erosion might gain additional information and insight from an engineer. Or lastly, using a third party to provide alternative dispute resolution services, such as a mediator who would be neutral and encourage all sides to work together to create a mutually agreeable solution. So finally, we want to apply our rules consistently, but be flexible. It doesn't necessarily mean enforcing to the exact letter of the law. If, waiving a late fee here or there, or something like that. The ultimate goal is to protect the community and to protect harmony. And so you want to take your steps to do that and to encourage your owners to live in compliance. And the intent and the spirit of the rule is more important than the exact enforcement. So I encourage you all to encourage your other board members and committee leaders to look for compromise and empathy to any owner's effort to balance the rules and with a desire to personalize their home or improve their home or their unit. But that does not mean ignore the rules. It doesn't mean allow an owner to railroad you. I would never say that. So, so which of the following statements is false? Alternative dispute resolution is ineffective for resolving serious disputes. Well, that's not. Well, that is false. That is false. Is often encouraged before going to trial. Well, that's true. We always encourage resolving a matter without having to go to trial. A voluntary resolution of a matter eliminates uncertainty, eliminates unnecessary exponential costs, time, and frustration. And involves submitting a dispute to an impartial party. Well, that is true about ADR. So your false answer is that is ineffective. Mr. Rollins is a personal effective coach. He wants to open his own business where he coaches salespeople over the phone on sales skills. He says he won't have clients visiting and won't do anything that his neighbors would even notice. Does this merit a variance? On the other hand, Mr. Santini has sold sports memorabilia online as a hobby for years. He wants to turn it into a full-time business, running it from his home. He says the daily deliveries and pickups shouldn't be too much of a problem. And since he uses a dolly to load multiple shipping boxes, the elevators won't be tied up for too long. Does this situation merit a variance? Well, I think Mr. Rollins would be entitled to a variance and Mr. Santini would not. Mr. Santini's business, I mean, it says right there, the elevators won't be tied up for too long, right? So not only would it be tying up the elevators to the detriment of other people being able to use it, it would also be an additional strain on the elevators, which if you have an elevator in your community, you know that they are a large portion of your monthly assessment. So to recap, congratulations, this is what we've gone over. We've applied the 6 criteria to determine whether a rule is valid. Is it legal? Does it have a legitimate purpose? Is it reasonable, fair, enforceable, and clear? And we described the procedure for developing association rules. Do we have authority? Have we evaluated the need for this rule? What will be the impact of the rule? We're going to determine the scope and we're going to draft the rule. Is it valid and enforceable? We provide notice and comment and we vote on the rule, and then we provide notice of the effective date. And we also describe the basic steps for enforcing association rules, the informal notice of a violation, and then cease and desist letters, a hearing notice, a hearing, a decision, and an appeal. our procedures and guidelines for conducting hearings. So the meeting should be open. You invite, or you open the meeting, you invite the complainer to speak. The panel asks questions, the violator speaks, more questions, anyone else then to speak, and adjourn. And then don't forget to send out the decision. And lastly, alternative methods for resolving conflict. Pick up the phone. Go have a conversation with your neighbor about the situation. Involve an expert and engage in alternative dispute resolution, such as mediation. And that is the end of our presentation.
Great. We have several questions, Sarah, for you.
Okay.
Let me get them up here. Hold on a second. Wait 1 second. Okay. First one, our indentures only say we can enforce property upkeep. It has been difficult. Would rules then become a legal part of the indentures?
Well, if you are authorized to enforce legal upkeep of the properties, there should be somewhere else in your documents that says what you may or may not be authorized to do. So if you, let's say I just refuse to cut my grass. I refuse. I hate it. I hate cutting the grass. I'm allergic to the grass. It's just, I get all sweaty. I don't want to do it. I hate it. So more than likely, you probably have the authority to send me the notice of violation. And then either find me for this situation or or cut the grass and charge me for it. So depending on the circumstances, like Mr. Matthews' Christmas ornaments or decorations, one of those options was remove the decorations and charge them for it, if you remember that. And I said, well, I kind of like that option. But that's more suitable in situations such as cutting the grass, or if an owner's home is in disrepair and they won't fix it. And it really depends on how your documents read. They may only allow you to enforce by taking the owner to court, but there might be some language tucked away in your documents somewhere that you can't see it or find it, but I would be able to find it, or one of the other CAI community association lawyers be like, it's right here. This is how you do it. So it really depends, excuse me, on what your documents say. But oftentimes a board member might not be able to find it or understand exactly how to apply that authority that's in your documents. And so that's what these rules, that's the point of this program, is you might have the authority to enforce something, and oftentimes we have to pull it from a bunch of different spots in your declaration. So if it's not clear to you how you might be able to enforce a particular situation, I would encourage you to ask your attorney to interpret your documents, and with the facts, you know, with the specific facts that you're trying to enforce.
Great, Sarah. Next question. Would a rule to disclose the names and amount owed of individuals that don't pay their annual assessments, is that a good rule?
That is a horrible rule.
I was just going to say that too, but go ahead, Sarah. You tell us why.
And everyone wants to do it. Everyone wants to do it. Okay, so we go back to, let me find what makes a good rule, right? So it has to be legal. Okay, so that might not be considered legal. It might be considered harassment or something of that regard. A rule has a legitimate purpose if it relates to the operation and mission of the association. Okay, so what is the purpose really in doing that? Isn't the purpose of a rule like that to humiliate or otherwise embarrass an owner who is delinquent? So that's typically that's typically how those are viewed. So you can make rules to enforce the assessments, you know, to find the authority in your documents for what you can do to collect. And you might be able to withhold pool passes or access to other amenities, prevent them from voting, things like that. But publishing a list of delinquent owners for the sole purpose of, so that the whole community knows who's delinquent, no, especially if you include names. That doesn't mean that you can't openly talk about the delinquency rate in your community. There's diplomatic and tactful ways to do it, and there's ways to do it that are really just for the purpose of embarrassing or shaming the owner, and that's not right. That doesn't foster community. So
Absolutely. Good answer. Is there guidance for the penalty? Should there be a fine schedule, or is it okay to make up the fines as you go?
You can, it's good to have a fine schedule, but you can also make your fine schedule flexible enough to where you can make the punishment fit the crime. If it's worded properly, if you can word your fining schedule in a way. It takes a little bit of creativity, but they can be worded in a way that, for example, I had an owner in a condo come outside and started shooting his gun toward the building and the dumpster and in the air, brandishing, shooting, you know, like, holy cow. Like,
Wow, yeah.
yeah. So what do you fine someone for that, right? Oddly enough, it was specifically stated in their declaration that brandishing a weapon is prohibited. And it was in their recorded declaration. But, you know, we fined him $1,000 and he doesn't want to pay it. Go figure. So, but anyway.
Okay. Next question. Is it required that the complainer identify themselves, or is it okay to have anonymous complainers? In my neighborhood, one board member always identifies violations, claims they come from anonymous reports, and will not share the complainer's information with the rest of the board, ever.
Oh, well, I think that the complainer should be documented, at least to protect the board. The complainer should be documented, because you should have that backup. If the violator, if it goes to court and you're looking at a judge, or I'm there looking at the judge on your behalf, well, you sent him this violation, this violation, this violation, this violation, this violation, this violation. What do you have to back that up? And there's nothing at all. Yeah, I would say that is certainly not best practice, and it puts the board in a precarious position.
I agree. Okay, next question. How do you enforce him paying the fine? Is it attached to the annual assessment?
Well, it depends on your documents. I should get that tattooed to my forehead. It depends. But typically, unless your documents are written in some other fashion, the fine is imposed and due immediately. And oftentimes your documents will allow for a fine to then become part of your lien against the property. So, but sometimes you might have to sue for it. So it depends.
Next question. Does each owner have the right to see the details of the association? Are they not members? Referring to the delinquent thing.
Say it again.
Does each owner have the right to see the details of the association? Are they not members? I'm not really sure what they mean by that, but basically, does an owner have the right to see the details of the association, I guess? So I'm assuming maybe financial reports and things. I don't know.
No, that is not on topic, for one. Every year the financial reports are provided to the owners, and financial reports means your income and expense sheet, your balance sheet, your budget. It does not mean fine detail of whether Sarah Beltman paid her assessments and did Kathy Roth Johnson pay her assessments. That's not the financial records of the association, unless your documents are written in a way that more broadly define what an owner is entitled to access or view.
He added to it. He said, you said the delinquency should not be disclosed. Does not each member have the right to see that information? And how do we justify keeping that from our membership?
So like I just said, so they have you can talk about revenue in, revenue out, and you can talk about your state of delinquencies. And that is not the same as publishing and posting the names and addresses of delinquent owners.
Agreed.
So there's a way that it can be done with some level of finesse, but no, I mean, and I'm not saying people shouldn't know that I mean, if I lived in a community that over 50% of the owners were severely delinquent, yes, I would want to know that. But, and again, it's a tricky area. I would do anything like that upon the specific advice of counsel who knows what you're trying to do and why, and yeah, come up with a strategy for curing such a situation.
And when in doubt, contact your attorney.
Yeah. Yeah.
I'm sorry, there's another question. We make all financials available to owners, but not the names of who is delinquent. We let them know how much the delinquencies are, but not who has them.
That sounds more in line with what I would recommend. Yeah.
Yeah. Any more questions, anybody? Give it another minute. Thank you, Sarah. You did a great job. Thanks everyone for your patience while we had a little technical difficulties, but Sarah did awesome. Thank you. Oh, I'm sorry, we got one more. Thank you, they're saying thank you.
Thank you.
Yeah, so thanks, Sarah, for doing this. Next week's topic is fundamentals of financial management. Next Thursday at 6. We hope to see you there. I will be happy to send the PowerPoint slides to everyone tomorrow. If you have any questions, please don't ever hesitate to reach out to me. Anything else? I'm trying to think. I think that's all we've got. If for some reason, and I know several of you have paid for the whole series, if for some reason you can't make one week, it's okay. If you don't make it, I will send you the recording the next day. So if you can't make it, we totally understand. But if you can, we'd love to see you. So thanks, Sarah. Thanks, everybody. I hope you guys have a great evening.
Thanks, everyone.
Bye, everybody. See you next week. Thanks, Sarah.
Thank you.